So it's our contention that pursuant to Worley, the Supreme Court case of Worley versus Central Florida Young Men's Christian Association, 228 Southern 3rd, 2017, the Price versus Hannah's case, 954 Southern 2nd, 97, 2007, and Cooper Smith versus Bryan case. 1 second. 91 Southern 3rd, 246, Florida, 4 TCA 2012 case. That this information is
Not discoverable.
not discoverable.
Yeah, absolutely. So, and we can go through all the evidence, but I had read a response because I've read Worley and very familiar with this line of cases. This isn't the first time I've addressed this issue. Why is it your contention that this information should be produced?
First of all, there's the case law, both Worley and there's a recent 4 TCA case on last month called Lisa.
Yes.
Those cases deal with discovery from the plaintiff's law firm or the plaintiff's attorney.
I understand.
I'm not asking for any of that, Judge. What
But but this is a step even further, right? This is a non-party. To me, this is actually worse because this isn't even a party to the lawsuit or a law firm involved. This is a stranger to the lawsuit.
If I can put it in,
Sure.
can I put it in some context for you?
Sure.
Dr. Martin's a neurosurgeon. He hasn't done brain surgery in more than 10 years.
Okay.
He doesn't take call. He doesn't take health insurance. He doesn't take Medicare. He doesn't even use CPT codes.
That's his entitlement to do that, right?
No, I understand that, but what I'm saying is this is a $700 impact where he has billed outrageous amounts of money.
Okay.
And he's done surgery on both plaintiffs for this minimum impact. And he has tens of thousands of dollars.
And I understand you're going to use that to impeach his testimony and credibility with the jury, but that still doesn't mean that this information that you're seeking is discoverable under the case law when he's a non-party to the lawsuit.
Well, I guess my point is, Judge, for the bias, to examine the bias and reasonableness of the bills, Judge.
Give me a case that allows us from a non-party to a lawsuit. I'm not aware of any.
I can't jump at it, but I've had judges agree with me. Can I just...
Because the case law doesn't exist. Let me take a look.
This is an agreed order that these counsel entered into in a case in Miami-Dade.
That doesn't bind him. There's no collateral estoppel, sir. That's not a basis. Your objections are sustained. Thank you. Have a great day, everyone. Excellent job.
Thank you, Judge.
Thank you, guys. Can I keep the back of the paper, counsel? Very nice job. Thank you for being confirmed. Thank you so much. Okay. All right, let me go ahead and do these. Starting with motion calendar this morning. Newrez versus Everett, please. Counsel Lady on that one. Newrez versus Everett. Newrez versus Everett. No? Okay, all right. You know what, let me go ahead and do some case management conference hearings, and that way we can go ahead and take care of that for you guys. I have a couple CMCs this morning. First up, I have MD Solutions versus Garden of New Beginnings. Counsel ready on that one? All right, good morning. All right, good morning, counsel. What is the status of this case?
Good morning, Your Honor. Ronald Nyworth for defense.
Yes.
Current status is we had postponed mediation, hoping that we could get it resolved ourselves.
Okay.
We have as yet been unable to do so. I have discovery out there awaiting response, and that's where we are.
Would a formal order of mediation be helpful? And would that be helpful in getting the parties to resolve the case?
We are cooperative, and I think we can sort it out among ourselves.
Okay. All right, so Michelle, on this one, let's do a 90-day status conference then.
Okay.
So we'll follow up with you guys in 90 days to see where you are.
Thank you, Judge.
All right, thank you.
Should I put that into
Just put the order in there. Thank you so much. Have a wonderful day. Via Lago versus Manatee Bay Apartment. All right, good morning. Nice to see you.
Morning, Judge.
Good morning. What's the status of this
So
case?
I'm happy to report, I think we have a written agreement in principle that is pending. It has to go to the association's unit owner.
Okay.
So that's
60 days, you think?
Yeah, I think that's more than that. I'm hoping they're supposed to be taking their vote on April 30th.
Okay.
Hopefully we'll be done way before, but that would be great.
Okay, Michelle, let's do a 60-day status conference and hopefully we get the case dismissed. Excellent. Thank you so much. Deutsche Bank versus Scarmolino. All right, good morning. Good morning. What's the status in this case?
Judge, in this case, there's a foreclosure sale set for May 13th.
Oh, even better. Okay, so the case will be dismissed after the sale then, Michelle. That's fine. All right, thank you so much. Geico versus Walker.
Judge, on this case, there's an outstanding motion to compel discovery. We had it set for last week.
Okay, let's go and set it. You want to set it for hearing? Let's set it for hearing next week? You want to see?
Next week.
Okay, you want to see it? Great. Thank you so much.
Okay.
Yeah, just put that in the order. Set for UMC hearing next week. Carrera versus Greenbelt. What's ready on that one? All right, good morning. Grandmother Cooper? No? Okay, good morning. Nice to see you both. What's the status of the case, guys?
We're trying to do some discovery, Your Honor, which has been problematic, and what we discussed was if the court could give us an order to mediate within 90 days. That may save us a lot of money if we can settle it.
That's what we want to do to try to help you guys save money for a client. So 90-day mediation order, and then we'll do a 120-day status conference. For some reason, if it doesn't settle mediation, then I can help you guys out after that.
Okay, Your Honor, we said the mediation order, there's still...
Just put, she'll take care of that for you.
Oh, just-
Yeah, Michelle will take care of that, okay?
Thank you.
All right, thank you. Have a great day, guys. Thank y'all. All right, let me go ahead and start back on UMC then. Let me go ahead and do, please, Dukas versus Garraham, please. Motion to leave to amend. Council ready? Good morning. Good morning, guys. This is Dukas versus Landon. This is a motion for leave to amend. And I had a chance to read the motion. Is there any opposition?
There is. Morning.
Oh, there is, okay.
Robert Griffin on behalf of Ted Dukas, my Goldie Green, that's my son's alma mater. Did you go there?
No, but my son got in, so we're trying to decide. So we're trying to decide between Harvard, Dartmouth, Cornell, Penn, and UVA. We haven't decided yet. So did he like it?
A lot.
Off the record, all the stuff, so all the stuff?
Graduated maybe 3 years ago. Loved it.
Good choice?
Similar choices as...
Okay, all right.
Loved it. Make sure to
Okay.
learn that whole experience.
Okay, all right, so I will definitely take your positive recommendation into account. Okay, all right. So now, yes, now on the motion for leave to
Yes,
amend.
this is my opposition is the following. This case was previously set non-jury trial half a day.
Okay.
And sadly, I think 48 hours beforehand, counsel passed.
I know.
So the real only argument I think I have is that now they're looking to sort of start from scratch with the amendments and the
Okay.
additional affirmative defenses on a case that otherwise, but for the tragedy, would have
We've
been.
got forward.
Other than that, I will leave it to the court.
All right, responses?
Your Honor, frankly, though this case was set for trial and those circumstances occurred, even though this case is an 8-year-old case, it's essentially a brand new case in the sense that there's been virtually no discovery done, no depositions have ever been taken, there's only been one pleading. The case has been extended for this amount of time, largely because twice prior there were lack of prosecutions that the plaintiff was able to save the case from. And as I laid out in the motion, Your Honor, my client has had representation. It was the previous attorney was her father.
Yeah.
And frankly, looking at the record and the sparsity of pleadings, I think it's fair to say, and my client would agree, that perhaps she wasn't, while she was receiving the representation from her father, it was not perhaps the representation that she really needed in the case. And now that these events have passed and she has new counsel, and I was retained just last month, that
Well,
she's like the opportunity to defend
All right,
this.
I'll allow the amendment because the amendments we know are liberally granted, but the only issues we need to move the case forward is 2011. It's prejudicial to the other side. It's not really fair.
Understood, Your Honor.
So I'll go ahead and grant the motion for leave to amend. We'll deem them followed as of today's date. Let's get the pleadings closed. Let's get you guys at issue and let's get you guys get the case moving forward.
Your Honor, there's never been a mediation in this case either. Would it perhaps make sense for Your Honor to, and I don't know if
I don't know if he
counsel...
wants to do any discovery or anything. If you're
No,
ready.
we're all set. You know, that's what we said about the pleadings is accurate.
Yeah.
We're ready for trial.
Yeah, they want to go to trial, so let's do a quick, well, I can set you guys for trial quickly and then just get it teed up. I think that's in everybody's best interest. So let me set you guys for trial maybe even in like July, if that'll work then. And that would get mediation done quick, get a quick mediation.
And we get
the
discovery
case
after that.
over. Okay, Michelle, July trial date. Thank you. Yeah. We'll take care of it then, that's fine.
Yeah, well, I had only, until new counsel came, it was non-jury.
Non-jury.
He pled jury.
Jury, it's gonna be jury. How many dates for jury?
I would think, well, I would say probably maybe, I don't know how many witnesses
We'll
they could call,
we'll
but
still go non-jury on less than a day.
It wasn't even asked for in the initial complaint at this point in time, so there was a waiver of the jury.
and then if it's going to be non-jury, then I would think it's going to take a day.
Day, one day non-jury, July. Perfect, awesome. We'll send you a call.
I'll file a notice of unavailability today, Your Honor.
Yeah, we'll
Most
take-
dates in July.
Yeah, we'll take care of your vacation, that's no problem.
Thank you very much.
guys, all right. Let me go ahead and please do some B&B Carpentry and Cabinet versus B&B Contracting. Councilor Reagan, it's a motion to default final judgment. And I read everything looked to be in order. Do you have your proposed judgment form?
Yes, Your Honor, actually, I need the actual default entered and the default judgment. I have both.
Yeah, let's do the default first, and then we'll do the default judgment after that then. So if you just hand that to the bailiff, I'll be happy to sign it then. Thank you so much, have a great day. All right, let me do Losey versus Liberty Mutual, please. Motion to compel deposition. All right, good morning.
Good morning, Your Honor.
This is Losey versus Liberty Mutual. This is a plaintiff's motion to compel depositions of the corporate reps. And I raise your motion, and you may proceed when you're ready, counsel.
Good morning, Your Honor. My name is Julie Sullivan. I'm here on behalf of the plaintiffs. This is a simple first-party breach of contract action, and my office has been requesting deposition dates since January 9th of this year, and we followed up with opposing counsel February 15th and February 19th. They didn't reach back to us until about March, in which they finally gave us dates all the way in August, which is 8 months out.
Your Honor, our corporate rep doesn't have anything before then.
So let's get another corporate rep.
But Your Honor, also, our client was only served December 21st. They were asking for dates for depositions before any discovery was due, essentially when the complaint was filed. And we advised them, and quite frankly, we were trying to get this case resolved in the meantime, so it's not like we've been dragging our feet, but unfortunately, we don't have dates before then.
Well, I'm going to require you to give dates before then, otherwise you have to get another corporate rep. So I'm going to grant the plaintiff's motion to compel. Let's go ahead and give dates within the next 30 days, set the corporate rep down within 60 days.
Your Honor, I'm sorry, I'm on this case. Counsel, I didn't understand the record.
Yeah, sorry, I couldn't be able to read on behalf of Liberty Mutual.
Okay, that's fine. All right, thank you so much. Motion's granted. Have a great day, everyone. Grimsley versus Berman, please. That's right. All right, good morning. Is Mr. Grims?
I haven't seen him yet this morning.
Okay, let's wait and see if it shows up. Thank you so much. All right. Kimmel versus Wellington Regional Medical Center. That's right. Kimmel? All right, and they're telephonic, right?
Yes, Your Honor. Plaintiff is attending by phone.
Let me start to get my line and we'll get started with court order.
No, Your Honor.
Okay.
Good morning, this is John Wendell.
Oh, good morning, Mr. Wendell. This is Judge Sasser. I'm calling you in Kimmel versus Wellington Regional, and defense counsel is here in the courtroom. Are you ready for the hearing?
Yes, Your Honor.
Wonderful. We have a couple motions. One is defendant's motion to compel better answers to expert interrogatories, and the other one is defendant's motion for leave to amend the affirmative defenses. And I read both. Let me ask you, is there any opposition to the amendment of the affirmative defenses?
Yes, Your Honor, I'd like to be heard on that.
Sure. What's your basis to oppose it?
So essentially, Your Honor, it's our position that the defendants have waived that amendment, and I'll give you, Your Honor, a brief background if you'll indulge me.
Sure, of course.
Slightly.
Sure.
Your Honor most recently issued a trial order back in November 2nd of 2018. This case was, things were closed, this case was ready to be set for trial.
Oh, no.
In December, we plaintiffs sought a special set so that we could organize our client's travel issues, make sure he's available for trial. Your Honor did issue an order specially setting in January of this year. In February, the defendants moved for continuances, not based on any ability or need to amend, but based on their own conflict of trial schedule. And they filed, the court did grant a motion for continuance back on February 20th or thereabouts. In the interim, from actually the granting of that continuance and the resetting of a specially set date that we could all work with, the defendants both moved to amend their answers, alleging some new information regarding these affirmative defenses that they had now. Really, the defendants never raised that when they were seeking continuances. Whatever facts they're seeking to add to their answers now are facts that they've had for a very long time.
I know, but the problem is amendments are liberally granted even on the eve of trial, so I have no choice but to grant it. So I'm going to go ahead and grant the motion for leave to amend.
A motion two that we added on?
Yeah.
And it's the same?
Same thing, same,
Okay.
both are granted. Now let's do the more detailed one, the motion to compel the expert procs.
Sure, Your Honor. It's actually, Your Honor, only 3 interrogatories. It was interrogatory 3, 4, and 5.
Yes.
Your Honor, just to discuss the answers that the plaintiff provided, seeking the substance of the facts and opinions that the experts are going to be testifying to, we really didn't receive any substantive information at all.
I know. Let me hear a response from plaintiff's counsel on that first interrogatory.
So, Your Honor, this is a simple expert interrogatory asking for, what's this expert going to testify now? Provide that information. He's a standard of care and causation expert for ER physicians. That's his primary issue. He's given STD. His deposition is set for June. We think that our answers to the interrogatory
What else do you need on that one? Other than if his depo is going to be taken, what else do you need?
Well, Your Honor, the information that we're seeking is actually to be used and at least to have some idea going into his deposition regarding what he's going to be testifying to.
Can you just go ahead and update that and let the expert interrogatory answers and just give a brief summary? He finds no causation or whatever, whatever it is. Somebody grant the motion. Okay, grant that motion. Let's do the next one.
The next interrogatory was number 4. It's just asking for a complete list of basically the materials that the experts are utilizing or relying upon in their rendering of their opinions.
Sure, the reliance materials, do you have that for plaintiff's counsel? Do you have that for defense counsel?
Well, I mean, Your Honor, they're not asking us to produce the materials. They're asking us to go out of our way to create a list of those materials. That's outside the scope of 1.280 expert discovery.
No, you're right. You don't have to produce a list then, right? I mean, they don't have to have a list then.
Well,
They can say attached.
they could certainly attach it. Well, one of the things, Your Honor, is of course any materials that are provided to the experts are going to be correspondence from the plaintiff's attorney, so they have all that information.
But they don't have to put it in a list format.
They certainly don't have to.
Yeah, if you want to attach it or say, see responses to request for admission, a request for production, that's fine. So you don't have to answer that one. Let's do the third one.
The third is almost very similar to the first, state the opinion to which the experts are expected to testify.
Okay, all right, so I'm going to grant that one then. Just go ahead and give a brief 2 or 3 sentence summary of what the opinions you expect your experts to testify to.
Okay, Your Honor.
Okay, all right, thank you. And let's get the pleadings closed. I'll get you guys another special set trial date. Just go ahead and check the calendars, and I'm happy to special set it for whenever you guys want to.
Your Honor, we do not want to lose our trial date. It took us months to get that trial date, as you know.
Then we'll leave it as it then. September. That's fine then. We'll leave it as September then. So it's on, it's set, and you guys are good to go.
And then as far as the answers to the expert products, however many days plaintiff wants.
Is 20 days okay for the expert interrogatories?
Fine with me.
20 days it is? All right, thank you guys. Have a great day, everyone. Thank y'all.
Thanks, Your Honor.
Okay, thank you. All right, let me do Whitney Condo versus Lend-Lease, please. Counselor? All right, Mr. Russell, go ahead.
Morning, Your Honor.
Whitney Condo versus Lend-Lease. And this is the motion to stay, which I had a chance to read. Did you get notice to the other side? I just want to make sure.
There's, the complaint is not served.
Oh, it hasn't served.
Just filed it, literally last Thursday.
Okay, that's fine then. Okay, I'll go ahead at this point in time. What's your legal basis just for the ex parte stay?
The basis is that the statute requires us to file a motion to stay so that the...
Can be preserved.
Right, so that it can be preserved, and also so that the construction defect process...
Can be set. Okay, that's fine. I'm going to go ahead and grant it if you just want to hand an order up to the bailiff then. Wonderful, thank you so much. All right, let me go do, Mr. Grimsley's here. Grimsley versus Berman. All right, good morning, guys. With corporate. All right, good morning. We're here in Grimsley versus Berman. Could counsel please take their appearances for the
Yes, Your Honor. Kelly Schultz on behalf of J. Michael Berman.
All right, good morning, Mr. Grimsley.
Good morning, George Grimsley, the plaintiff.
All right, this is a defendant's motion to dismiss the amended complaint with prejudice based on the court's two prior rulings. And you may proceed.
Yes, Your Honor, this is the third motion to dismiss, seeking dismissal with prejudice pursuant to the absolute litigation privilege. With regard to the 2 prior motions to dismiss, Your Honor, granted the first one, granted the second one with prejudice, but because the plaintiff failed to show up at that second hearing, you get the opportunity to be heard, and that's why we're here today. Despite the plaintiff's multiple attempts to amend the complaint, the actions alleged are all related to litigation, are all within the context and course of litigation. As you know, the conduct that started this was Mr. Berman's representation of 2 other attorneys that were being sued by Mr. Grimsley in a prior suit. This most current amended complaint even alleges conduct that occurred within the course of this case in front of Your Honor. So it's all related to litigation. There's no question that it's related to the litigation and that it's relevant. Thus, it's given the absolute privilege as per the case law decided in our motion, and I'm happy to go over any more that Your Honor needs, but I know you've heard this a couple times.
Let me hear from Mr. Grimsley, please, response.
Thank you, Your Honor. What I tried to do is to be sure that when I appeared before you this morning, you would not have to ask me what new do I have to add.
Yeah.
I don't have anything new I need to add, but I do have something I want to emphasize.
Sure.
Yesterday, I mailed by fax a letter to the defendant asking the defendant...
I don't know if they got it. If you mailed it yesterday, they wouldn't have received it.
By fax.
Oh, by fax. Okay.
I always send things by fax.
Fax, okay.
Because it will avoid deniability.
Got it, okay.
And I asked them not to come to the hearing this morning and make any statements that are known to be false or maybe prejudiced.
Okay.
Okay, so now, I would like to think that I don't need to say anything else.
But let me, this is a
Because-
legal issue though, so why is
Okay, go ahead.
why is this not legally absolutely privileged? Because it's within the course of the litigation.
I'll answer that. I'll answer that. Number one is because based on existing law, in order for Attorney Berman to be eligible for absolute litigation privilege, the defamatory statements that were made by him and confirmed by Judge Goodman, I gave all of this to you.
Yes.
These particular statements,
But it was within the litigation, right?
yeah, but there's something that maybe you do not know
Sure,
or
yeah,
maybe
what happened?
don't understand.
Yeah.
Okay, yes, they were made during proceedings, but they were not before the proceedings before Judge, in your case, in this case.
But they were
okay?
still within the litigation.
That's all right, I have another part to add to
Okay.
it. So when that happens, and the subject matter is not relevant, and in this case, they were not relevant, not material, not pertinent, and had no relationships to anything.
But we don't consider relevance on litigation privilege. The question is whether they may be related to the litigation in the litigation context.
I hate to disagree with you, Your Honor, but there's a second part to this. They must be relevant. They must have something to do with it. And I gave this to you, and it's because of those things that he is not entitled to absolute litigation privilege. But what he is entitled to is what they call a modified or a qualified privilege. And when that occurs, I have the opportunity to prove malice to overcome that. Now, that's the law. I gave it to you.
Okay, thank you, Mr. Grimsey, so appreciate it. A rebuttal, please?
The rebuttal is that all of the actions that are alleged are relevant to the proceedings. If Your Honor read them, you'll see that none of them were malicious, none of them were outside the proceedings. There are no letters, calls, publications that were outside of the litigation. In fact, the conduct in front of, from the prior litigation in front of Judge Goodman, he dismissed it with prejudice. The plaintiff appealed, that has been affirmed. Judge Goodman's ruling has been affirmed. Everyone agrees that this conduct is within the course and scope of litigation and is relevant there too. So either way, this should be dismissed with prejudice.
I have to interrupt because I asked her in this letter not to make any statements that were either false or known to be false, and this is the case where she has done this.
She's just making legal argument. The motion. Go ahead, Mr. Grimsey, go ahead. Anything else you want to say?
It is something I want to say. It has to do with the fact that she's talking about the case has been appealed, which it was.
Judge Goodman's case, yeah.
That's correct. But it has not entered the final judgment of opinion in this order yet because I showed them things that they overlooked and they have not yet responded. It hasn't been fully done. I had a rehearing, in other words.
The 4DC granted a rehearing?
No, Your Honor, he has requested it, but they have not granted anything. All we have is the dismissal. The dismissal is affirmed. You're correct.
The 4DC has not granted a rehearing.
They have not.
So
I just want to let you know that I did.
No,
that I did.
they're going to do that.
I don't know what they're going to do.
Okay.
I just want to let you know what I did. And until they do something, it's not really final. I don't think.
Okay, all right. I'm going to go ahead and grant the motion to dismiss. Thank you. Have a good day. Thank you. With precious.
Thank you.
All right, let me go ahead and do, please, Sakara versus Florida Peninsula.
What about my two motions? That's on the calendar.
Okay, let's do your two motions then, that's fine.
Well, you have it before?
Yeah, let's do your motions, go ahead.
I don't need to repeat
Okay, that's right.
it.
Response?
The response, these are two motions for sanctions, Your Honor. These are motions for sanctions based on conduct in the rules regulating the Florida bar and the, the professional conduct, Your Honor. I brought the book.
Yeah, I think those need to go to the Florida bar. I can't issue sanctions for that. If it's a bar issue, that needs to go to the Florida bar.
I think that this is where I have to disagree with the court again.
Okay.
Because I provided the court, and you have it. It's not something that I'm saying that you don't have. Everything that I'm arguing this morning, you have.
No. But if it's a professionalism issue with respect to that, then it needs to go before the Florida bar.
Here's what the Supreme Court has already said in a letter that I got from the bar.
Yeah.
It says without any equivocation.
Okay.
That it's up to the trial courts to handle these kinds of disputes. which in this case is in your hands.
Okay.
You have the authority to dispose of it.
Okay.
I'm only talking about the Florida Bar complaint at this point.
Okay.
You have the authority to do whatever you think is appropriate.
Well, the Florida Bar is going to send it to a grievance proceeding. They're going to do whatever they can if it's appropriate. So why not wait and see what the Florida Bar does? Did they already dismiss it?
Hold on a moment. I have not sent anything.
Oh,
to
you
the
haven't
bar.
sent anything to the Florida Bar. Oh, I see.
Okay, and the reason why I haven't is because it's up to you to decide. They're telling me in my letter that don't come to us with these kinds of complaints. Put it to the lower court. It's in your hand.
Okay, all right. Let me hear a response.
Yeah, Your Honor, based on the rules cited by the plaintiff in this matter, I mean, these are not appropriate for sanctions. The preamble to the professional conduct rules says that the violation itself should not give rise to cause of action. Of course, we completely disagree that there's been any violation, but even to the extent there was, and there was not, it doesn't give rise to sanctions against the attorney who used the rules of professional conduct. I agree with you that that might need to go to the Florida Bar. I think the letter he's referring to was them admonishing him for sending multiple complaints about attorneys that were, and telling him that the conduct that needed to be dealt with in the course of the case and not keep involving the Florida Bar is my understanding of the letter.
Okay.
And so that's my rebuttal, Your Honor.
Okay, now don't forget you have the other part. Come through with that. Unless you have something.
Anything
Okay,
else?
yeah, it has the other motion has to do with prejudice statements.
Okay.
And that's the part that has nothing to do with the Florida Bar, but it does have something to do with the state attorney office.
What did the state attorney's office do? I read your motion. How can I help you with the state attorney's office?
Well, I'm not going to the state attorney office with anything unless I give you the opportunity to do something first. In other words, I think the statements that were made based on what...
You're telling me to report them to the state, you're asking me to report them to the state attorney's office?
I'm asking you to take action, and if you don't, it's up to me to decide what to do.
Okay, all right, so I'm going to leave the ball in your court then. If you decide to report them to the state attorney's office, then they'll decide what to do with the state attorney's office. All right, thank you guys, have a good day. Thank you guys. All right, let me go ahead and do Secura versus Florida Peninsula, please.
Good morning, Your Honor.
Good morning.
I have counsel available by phone.
Yeah, I just need a phone number.
That's right, 305-496.
496?
6942.
Okay, let me give a call.
I think everything's in agreement.
Okay, awesome.
Good morning.
Oh, good morning. This is Judge Sasser. I'm calling you Secura versus Florida Peninsula. Are you ready for the status conference?
Good morning. Yes, this is Chris Archie speaking.
Wonderful. And counsel's here in the courtroom. And what's the status of the case, counsel?
Your Honor, we're currently setting the court's June trial docket.
Yes.
However, we have pending dispositive motion. Request for summary judgment. We were attempting to get a hearing date in advance.
We're happy to help you. Just let us know how much time you need.
We're going to need about 15 minutes to get that done. The only thing we ask is if the motion's not granted, we do have to complete the expert discovery. So we're going to ask if we can do an August trial.
Yeah, that's fine. As long as both sides agree, so I'll take you off June. We'll put you in August instead, and we'll hear your MSJs for you whenever you guys want to.
If there was anything available on...
Michelle, just email Michelle. She'll take care of it.
Perfect. Thank you so much.
All right, thank you guys. Have a great day.
And do I need an order from us, or?
No, Michelle will take care of it.
Thank you.
Michelle send you a new trial order today. Michelle for June.
Okay.
Okay, perfect. Thank you. Here's the case number. Case number, Michelle for June. Thank you. All right. Let me go ahead and do Long versus Macaroni, please. Motion for continuance. Melvin Long versus Macari. Nobody's here on that one? Okay. Let's please do Bastion versus Bethesda Hospital.
What do you got?
Come on in. Come on up, guys.
Thanks.
All right. Do we have a court order?
Thank you, Your Honor.
Nope, sorry. Thank you. Have a great day. Court order? Nope. Okay. All right. Good morning, everyone. We are here in Bastion versus Bethesda Hospital, and this is defendant's motion to dismiss count 4 of the amended complaint. And I had a chance to read the motion. You may proceed when you're ready, counsel.
Good morning, Your Honor. Robert Trevias on behalf of Bethesda Hospital East. Judge, this is our motion to dismiss count 4. This is one of the counts of our plaintiff's amended complaint. Count 4, which is seeking, plaintiff is seeking to broadly expand the hospital liability in the state of Florida to hold that all hospitals are liable for all obstetricians under WACS. I believe that is an extremely broad reading of WACS. WACS was actually limited by the 4 DCA. Subsequently, Christensen, Kepler, which I provided to Your Honor.
I have that.
And I apologize for the late filing yesterday evening.
No, I read everything, that's fine.
So our main position is that the count 4 just simply fails to state a cause of action. The law does not support the claim.
Okay, response, please?
We're relying on the same statutes and regulatory rules that wax decided as the controlling authority. There are some cases to the contrary in other districts, but they're not binding as wax.
Let me just ask you, is there any appellate authority from our DCA that allows this type of cause of action as currently pled to stand? That's my only thing. I mean, I know we have wax, but is there anything else, any other DCA cases?
I think there's one on Emmy South. It has to do with emergency department.
I have brought Amy's up before, but have we pled what we needed to in terms of holding the hospital fully responsible for the OBGYNs in this situation?
I think so.
Okay, let me hear you, Rebuttal.
Well, good. In terms of, I believe it's Newbold, Ferguson, and myself. And one of the things that the court touched upon is the fact that there was a lack of control and
That's
choice.
the issue. Yeah, I didn't see that pleading issue, the control issue.
What was pled was when she arrived in active labor to the hospital, this obstetrician was provided to her, and she was not given a choice of obstetrician. That's completely.
But the control issue. So that's the element I think is missing then.
Control would be an agency.
I know, but you need to plead it though. So.
It is in the count. The count is done before you.
Okay, all right.
Good, as pled, and frankly, even I think if there's a modification to the claimant to add an element of control, I still don't believe that this broad of a reading what it would do is it would expand hospital liability to hold hospitals liable for all obstetricians on top of, and then logically the following would be to also hold them under these statutes and regulations, to then hold them liable for all surgeons and for all physicians.
I'm going to, based on what the allegations are in the complaint, I'm going to deny the motion to dismiss, but I'm going to invite defense counsel to raise this issue on a summary judgment, because that'll be much more appropriate for me to make the determination on summary judgment. So the motion to dismiss is denied. How much time do you need to answer that count?
20 days.
Is that okay? 20 days? And then we can go through the full wax analysis in terms of what the allegations are, and then we'll have affidavits. That's what I've done in this situation before. If there's affidavits of the control issue, those types of things. Okay, thank you guys. Have a great day, everyone.
Would you like me to prepare an order?
Yeah, that would be excellent. Thank you guys so much. Let me do Stubbs versus BJ's Restaurant, please. Motion to help. All right, good morning. This is Stubbs versus BJ's Restaurant. No? Okay. This is plaintiff's motion to compel compliance with the court order dated February 19th. And you may, I read your motion. You may proceed when you're ready.
Morning, Your Honor. George Backlar on behalf of the plaintiff. Judge, I'm happy to tell you that working together with counsel, we've been able to work out 98%.
Excellent.
And so we're not seeking sanctions. There's only 2 interrogatory questions that we need the court to rule on. And Judge, this is a premises liability negligence action, but it's a little unusual in that the plaintiff was leaving the back of the restaurant from the patio area.
Okay.
She went to open the gate, fell off onto her foot. And interestingly and also significantly, there's video right after the incident where an employee tells the manager that gate's been broken since the day the restaurant opened.
Okay.
So in any event, we served standard court-approved interrogatory asking for the facts supporting affirmative defenses. They've raised 3 affirmative defenses that I'm seeking facts. One is that the plaintiff was negligent. And so I want to know, what did she do wrong? Did she pull the gate too hard? Did she go out a wrong gate? Second is they say it was open and obvious. So I want to know, what was open and obvious? The third was they say, and this was a very acute injury to her ankle which required surgery, they say that injury came from another incident. So I'm saying, tell me the incident. So I asked for those specific facts. They said they would give a better answer, but they didn't want to give those facts. The second interrogatory that we had a question about is, I asked for the names and addresses of the employees working that day, which is especially appropriate since they said it was open and obvious. So I want to speak to those employees. They agreed that they would give us the names, but they didn't want to give us their addresses. And counsel said we would, send care of our law firm. And I said, I would accept that as long as if any of those employees from that day leave the employee of the defendant, that you let me know within 20 or 30 days what their address is. And counsel couldn't agree to that. So that's what we need help with.
Let me get a response, please.
Good morning, Your Honor. Kelly Brandon on behalf of the defendant. The only issue that we had was specifically with the proposed agreed order and the language that was included in the proposed.
Well, you guys can work on the order, but why not give more facts in support of the affirmative defenses?
And we've said that we would give facts to reasonably inform adversary of what is proposed to be proved. He just had put in there with specificity and...
But you do need to give some more information, so I'll require the language with specificity then. Because you have to be specific. If you're alleging comparative negligence, what did the plaintiff do?
Right.
So it's only fair. That way they can take this discovery. And on the list of the other interrogatory?
Right, Your Honor, we had agreed to provide the last known addresses of the employees that had left. We have agreed to provide care of our law firm for the employees that are still there.
Okay.
The only issue that we had was that he specifically wants us to let him know within the 20 days that somebody has left the employee.
Okay.
We said that we would provide, if we could not produce them, we would provide their last known address.
I think that's fair.
As
They
soon
don't need anything more than the last known address?
Well, no, just the timing. We're set for trial in August, and so I just wanted a time frame so that I don't find out a week before trial, those guys aren't there, we can't produce them, and then we have a problem.
Okay, got it.
Your Honor, as soon as he requests a deposition of any of our employees, we would provide.
So we'll get the deposition dates within like 10 days after each deposition is requested.
Okay, now Judge, the only thing I was asked is, in terms of timing for the better answers, we have the first liability witness,
Okay. We
11
can
days.
expedite it. You think maybe 5 days is okay for the better answers to interrogatories? Because they need it before the
Judge, I can give
depositions.
them 10 days,
Okay,
because
10
the
days.
depo's in 11
Okay,
days, so I'm
that's
going to ask for
All right, 10 days,
better
please. I'm going to grant your
answers.
motion 10 days to do better responses. You're going to need them before the depots.
Yes, and we're going to.
Thank you, guys. Have a great day.
Thank you, Judge.
Just for clarification, so that if you request a deposition within 10 days, we
You need
will
to give them
provide
the-
the last known
exactly.
address or produce that.
Either way. Yeah, just to make it easier. You don't need to go anything further than
And that's
that.
fine.
Okay. All right, and Northern Trust versus Oxenberg, please?
Yes, good
All right,
morning,
good morning.
Judge. Thank you.
Yes.
On behalf of the plaintiff, Judge, this is a motion to reschedule a foreclosure sale and amend the summary judgment.
Okay.
There had been a bankruptcy, and I want to put it back on.
Amend. Why are we moving to amend the summary judgment?
They all had additional interest and legal fees since
Okay.
that time.
Okay, and that's it? And then what, and you're going to cancel the sale date? When's the sale set for?
No, we don't want to cancel it. We want to set a sale date.
Oh, okay. When
We
you-
entered into
yeah,
agreement
okay.
with them
All right, that's right, it's an agreement. When do you want the sale date?
after July 16th.
Okay, after July 16th sale date, and I'm going to grant your motion then.
Okay,
That's
thank
what
you,
we're
Judge.
doing. All right, let me go ahead and do Finnegan versus Citizens, please, Councilor. Okay. All right, good morning, everyone. This is Finnegan versus Citizens. Could council please state their appearances for the record?
Yes, good morning, Your Honor. Jenny Desorni on behalf of the plaintiff.
Yes, good morning, Your Honor, on behalf of the defendant.
All right. Council?
Jordan Landy for defendant.
All right, good morning. This is defendant's motion to dismiss the deck action, and I read your motion. You may proceed when you're ready, council.
Thank you, Your Honor. Your Honor, I'll keep it brief. This is a first-person property case, scope and pricing. Given that we have extended coverage and a breach of contract has been pled in the
They're
complaint.
pledging the alternate. That's what they do all the time.
Your Honor, we feel that anything that is not, or anything that would be addressed or resolved within the deck action would be addressed within the
I
breach
know.
of contract. So it's-
I know, but I've heard this motion multiple times. I'm going to go ahead and deny the motion to dismiss. How much time do you need to answer the complaint?
Can we have 20 days, Your Honor?
Sure, 20 days.
Thank you, Your Honor. That's fine. I have no objection.
Okay, perfect. Thank you, guys. Have a great day, everyone.
Thank you.
Thank you, Your
All
Honor.
right, let me go ahead and do, please, Messina versus Lake Worth Enterprise.
Good morning, Your Honor.
Good morning. We have court reporter?
Yes.
Okay, all right. Good morning, everyone. This is Messina versus Lake Worth Enterprise. Could council please state their appearances?
Sure, Your Honor. Good morning. Greg Hollander on behalf of the plaintiff. Paul Milberg on behalf of the defendant.
All right, good morning. Ms. Hollander, this is plaintiff's second motion to overrule defendant's objections and motions to compel better responses to the initial request for production. And I went through both, and you may proceed when you're ready.
Okay, Your Honor, Ms. Milberg and myself have worked together, so we've narrowed it down. The only issue, number of issues, number 21. Okay, so that's what we're here on. If you take a look at 21, Your Honor, this is probably not unfamiliar to you. We are requesting the complete unedited, unredacted audit trail run at the uppermost management level. Now, this is a wrongful death nursing home case. Obviously, there is a question as to documentation. We want to know who did what when. These audit trails tell exactly that. They should be part of the patient's EHR. And we don't feel, certainly, this is not a vague, ambiguous request. Mr. Messina was only a resident there from August 4th to December 9th. And that's what we're requesting. We have trial. We are set, I believe, number one for May 6th to begin. So we need this, ASAP.
Okay, response, please.
We are set for the 6th. Discovery is over. We have taken everybody's experts.
Requested before?
And we objected, and it hasn't been ruled on yet. And the problem is this, it's not an issue in the case.
We have taken everybody's
That's what
expert.
you're saying, their expert may think it's relevant, right?
I've taken their expert. Basically, the basis of the case is we don't have enough documentation. If there was more information, it would be of assistance to us.
Okay.
There's no relevance whatsoever. Everybody's experts have taken. Nobody's saying there's mysterious people who did things that weren't documented. Quite the opposite. Their expert says
But they just,
there's not enough.
the Planners Council just wants to bootstrap to make sure there's not missing anything.
Well, and I understand that, but now we're set, number one, for the
Okay.
6th.
Okay.
The representative who could tell me the expense, what
Yeah.
would need to be done, is not in town until the 22nd.
I can guarantee it, but it might take you on the trolley, that's the only problem then. So-
And that's why, if we're going to start opening discovery, experts are going to be involved. There's a number of issues. You see what I'm saying?
No, I know what happens.
And I don't believe it's relevant.
Okay, well, in all fairness, it's very relevant. This was
No, I'm
requested.
gonna grant it.
Okay,
The only
let
question
Brett.
is, can we get them, because if your expert's gonna need to review it, and based on your experts, if you change opinion, their expert might need to address that. That's my only concern. So,
Well, I understand that, Your Honor.
if
What
your
I-
expert gonna change your opinion based on
Well,
this?
I don't think so.
Okay.
But what I'm saying is, it just, from our standpoint, allows us to go into further inquiry with regards to, at trial, the defense witnesses in terms of the people, the folks at the nursing home, the DON, all these folks who
Are you
work
gonna
there.
be changing any witnesses or anything as a result of this?
I mean, I can't sit here and tell you, I can't guarantee that, but this is my concern, Your Honor, is that, this is simply a query that they do, it's a printout. There's no reason why we shouldn't be able to get this in 5 days, 7 at most. And if there's an issue,
Okay, no, they're gonna file an affidavit, because I'm gonna give them a chance to file an affidavit in terms of the time expense associated with it. Sometimes, some nursing homes say it's more expensive than others.
And here's my, and again, I want to be clear on a number of things, because we are under
Yeah.
you control. First of all, it says unredacted. I have to look at it.
No.
Okay, so I presume Your Honor is not saying it's unredacted.
No.
That's the request. So my objection is reasonable. I want to put that on the record. We didn't make an unreasonable
Yeah, okay.
objection. Also, again, I have the representative who I need to talk to is out of town,
Yeah.
unaccessible till the 22nd.
Okay, so I'm gonna have to give them a little bit of time till 22nd. Let me give them till the 22nd then at least. Let's see where we are, and then if that changes the trial date, I could try you guys later in May if I need to. That's not a problem too.
And again, I'm not asking for
Yeah.
contingency.
No.
I've actually
Leave it.
filed, they took my expert Monday, I filed my
You're
motion
ready
for
to go.
summary. Well, I filed my motion for summary judgment
Okay.
yesterday.
Then we can
A
set that
day
later.
after,
Not a
2 days
problem.
after my expert. So we have an issue, there's a lot of issues. And finally, because we're
And email
here,
Michelle if you need a hearing date on your MSJ too.
but I think he has time to respond.
Yeah, we just gotta-
That brings us into the trial date, so we'd like to.
That's what we can do. We can, like I said, I can push you guys back later if you need to.
but I think that the deadline for dispositive motion, I think, has come and gone, but in any event, we just got a yes.
Okay, so let me do one thing at a time then. Let me grant your motion to compel, but I'm gonna give you time till your expert, till your person gets back, and if they need to file an affidavit of burdensome, what's required, they're welcome to do all that stuff.
And if I can get it earlier,
Okay.
I've gotten along, I will
Okay.
say it in
Excellent.
open court, I will provide it as soon as I can.
Excellent, that's
so that
perfect.
we can-
Okay, so motion's granted.
Okay, but Grant, I want to put in the order, this timing issue, I don't want to just leave.
Yeah, no, put the 22nd then,
Okay.
yeah, till the 22nd, for the 23rd.
Could I say the 23rd, because I think it's gone through.
Let's do the 23rd, production by the 23rd then, that's only fair.
Okay, and Your Honor, we have agreed, like I said, to some of the other numbers. What I can do is submit an order electronically. Can I incorporate those other numbers in there? Is that a problem for the
That's
court?
fair,
And what can we agree to on those numbers? 5 days? Is that good enough for that?
On the other issues, is 5 days okay? Is that enough time for production?
Let me look very briefly.
You know, why don't we just say, put the 23rd on that as well?
Yeah, that's fine, we'll do the 23rd.
And again, in open court, represent, as soon as I can get it done, we're set for trial, I want to move.
Yeah, I know you guys
as
want to
quickly as
report,
possible.
and if you need a hearing, help with your MSJ hearing, just let Michelle know.
Thank you very much.
Thank you, Your Honor.
Guys. All right, let me go ahead and please do New Res versus Everett. New Res Everett. Anybody else here from UMC? You need to please make your paperwork. I know I want to take you guys last. Go ahead, Mr. Chapman, come on up.
Status, though?
Oh, no, you guys will go at the end. All right, come on up. All right.
We're here for a CMC.
Yeah, come on up. Oh, no, okay, which case are you hearing?
Ceremony.
Oh, Scaramellino. Yeah, that's fine. Let's go do the CMC then. Anybody else here on Scaramellino? No? Okay, all right. Okay. Yeah. Yeah, I did. I didn't think anybody else was here then. What's the status of the case then?
The last time we were here, I mentioned we had a short sale contract. They were going to give us time to see what we could do with that. Short sale contract was delivered shortly afterwards to the plaintiff. 2 days ago. They sent us a long list of documents they want, so we're still pursuing that option. We just need.
Okay, let's give more time, Michelle. 90 days. Okay, all right, thank you so much. 90 days, that's not what's that. All right, I have a non-jury trial, Bank of New York versus Wills. Coming up on the non-jury trial. Okay. All right, good morning.
Good morning.
This is, Bank of New York, Mellon versus Mills, and it's your non-jury. You may proceed when you're ready.
Adam Levine on behalf of the plaintiff. Your Honor, there seems to be a little bit of misunderstanding in my office. My office set this up for trial, well, there's notice of trial.
Yeah.
There's a notation to the witness saying this is set up for certification of business records,
Okay.
but it's not.
Not a problem. You can reset it then. I don't have a problem.
Witness is in Delray. He can be up here later this morning. If that's okay.
Not a problem. Why don't you just, let me know. Just email Michelle, we'll do it later this morning.
Later this morning?
Yeah,
Okay, I'll let him know.
Yes, let me know. Not a problem.
Thank you.
All right, let me go ahead and do Gal versus Citizens Property. GALE versus Citizens Property. Anyone here on that one? All right, yep. Okay, all right, council's here. And the last one I have is Gibson versus Siskin. That's the last one I have on that.
This is South Ocean Gale, right?
Yep, South Ocean Gale, yep. That's a plaintiff's motion to amend.
I don't know what plaintiff was here, I thought I saw.
Anybody here for the plaintiff? They're not here. And citizens' response, they're not here. And the motion is dismissed. Nobody, are you sure they're here? I didn't see them.
I saw someone sign in, so I don't see anyone here.
Maybe they stepped outside. Do you want to call and see where they are? I don't know where they are.
I'm covering for my partner, so
Okay, then it'll just be reset then. That's not a problem then. We'll just reset another day. Nobody's here.
Jose Campos.
Nobody's here. Anybody here on South Ocean Gal?
I think she was.
There was a lady who was here, she argued a little bit earlier, I think she stepped out.
Is she outside?
Okay, that's fine. Why don't you just leave? All right, come on up on Gibson versus Siskin, please. All right, this is the case management conference. I heard from the professionalism council. I want to table everything in this case pending professionalism council. A new judge is coming in. You guys are going to have judge marks. Okay? All right, good luck. Thank you guys. Have a good day. Thank you guys. All right, anybody else here for CMC or UMC? Which case you guys here?
Judge O'Rourke Long versus Marchese.
Oh, yeah, come on up.
Your Honor, I'm on that case.
Okay. All right, good morning. All right, can counsel please take their appearances for the record?
Yes, Your Honor, Nneka Uzodinma on behalf of the defendants.
Good morning, Judge Sweet with back to the plaintiff. Sorry, I had to step out and down the
No problem.
real quick.
No problem. Let's go ahead and do your motion. I read your motion.
Right, Judge, just a motion, defense motion for continuance. I've listed some issues, particularly that were still outstanding. I don't believe that plaintiff's counsel has an objection.
Not at all. I special said everything. When do you guys want me to set you for trial?
Just wanted to keep a short leash on it, maybe like roll it for about 4 months or so. For us to just renotice it or get a date, or
We'll get a date right now. Just tell me what month you want.
what are we set for, June?
June, so you want to do like November? September, November? September, November, Michelle. September, November for trial. Okay, great. We'll send you the call order. Thank you guys. Thank you, Judge. All right, let's get set up for Lauer, and then we'll be, did you find the attorney?
I just want to establish a couple things for the record, just to inform Your Honor. Judge, I actually noticed because I recognized the name that was signed in. She was here on Finnegan versus Citizens. Just to give you an idea of what we're dealing with here, this is, I'm not going to argue the motion, but I kind of want to present for the record and just let Your Honor know that the reason that they're trying to amend the complaint is to add a second complaint where it's under investigation. Actually, the EUO is set for today. So it's an examination under oath, and they've been kind of playing games with us and not showing up at the hearing.
You know what, as long as it's like, you know what, I'm going to deny your motion before you come in.
Thank you.
Okay?
I appreciate
All right,
it,
thank
because
you,
they
guys.
were here. And I
No,
established
not a
that.
problem. Not a problem, I appreciate that. Okay, go ahead and get set up for the 9:30, then we'll start the Q&A. No problem. All right, go ahead and set up, and then we'll start about 5 minutes from the 9:30. Thank you, guys.
I see that. I didn't order.